guest is Neha Srivastava ma'am. She is a seasoned patent attorney. She is a partner at Remfry and Sagar and a lead person at its Bengaluru office. She has over 15 years of experience in representing patent matters for leading companies and counseling clients on IP strategy and portfolio management. Her practice focuses on patent drafting, filing, prosecution, searches, oppositions, and providing opinions on patentability, invalidity, infringement, and biodiversity related issues. With her deep understanding of complex technical issues, ma'am has successfully represented clients across diverse areas of technology, including pharmaceuticals, chemical, and life sciences. Her expertise in the field of biotechnology, including genetic engineering, gene editing, biotherapeutics, antibody technologies, and medical devices, is particularly noteworthy. Her long and varied experiences equip her with the ability to provide solution centric advice tailored to commercial goals of clients and secure patents of precedential value. In her present role, she is also involved in innovation capture, strategic IP management, and IP risk mitigation related activities pertaining to R&D portfolios of several multinational companies. Her in-depth knowledge of Indian patent law enables her to advise across diverse platforms and lead successfully through initiatives aimed at setting up of new processes with operational efficiency. She also frequently advises budding entrepreneurs, startups, and MSMEs on managing IP portfolios and developing effective patent protection and enforcement strategies in India. A biotechnologist turned lawyer, ma'am is a qualified attorney and registered patent agent. Prior to joining the firm, she was associated with the Energy and Resource Institute, TERI, where she worked on projects and programs sponsored by Biotech Consortium India Limited and Department of Biotechnology, Ministry of Science and Technology, Government of India. She speaks often on patent issues and has also authored several articles on patent law and practice published in leading intellectual property publications. In addition, she represents the firm at several international and national conferences, including the Association of Biotech Led Enterprises, which collectively represents the Indian biotechnology sector. Ma'am, we are honored to have you here. I request you to please share your insights.
Thank you, everyone. It's a pleasure to be here, and thank you for a wonderful presentation. You have actually done half of my job. So brilliant, and I was very fascinated to see the kind of responses that were coming from you all. Uh, for a second, I thought maybe I would be interacting with a very naive audience, but you guys are fabulous. I mean, you already know so much. So my presentation today would focus. Now I have changed the plan actually. So it will focus on not addressing what and when, because that has already been discussed and addressed. I'll take you to the why of the whole thing. Why we need to protect IPR, why we need to protect it effectively, and as a bird's view, a holistic view of the entire scenario, where we stand uh, as a country and as IP, IP owners in the world map. But before I begin with just 2 to 3 slides on the firm, and I promise that it would not be more than this. So Remfry and Sagar was founded in 1827. That's a very old firm. It is perhaps the oldest and one of the largest in India. We have around 250 employees with 100 attorneys, including 14 partners. The head office is in Gurgaon, with branch offices in Chennai, Bengaluru, and Mumbai. And we represent over 8,000 clients worldwide. Now, just because of the timeline, you can see 1827 is the time when there was hardly any innovation in India. What the kind of innovation that we have been seeing is only perhaps 10 years or maybe 2 decades old. So what were we doing then? You know, we were actually representing all the foreign companies that were coming to India to protect their intellectual property. So that is the reason why almost 99% of our clientele has been in international, with US followed by Europe, followed by Japan, and the rest of the world. But I'm very happy to share this that being on the other side, representing the foreigners, the kind of shift that we have seen in the last 10 years, when we are seeing more and more innovation coming up from the Indian community. And that gives me a great pleasure, in extending these kind of services to the Indian clients. And now I think we started off with 3% representation to the Indian clients, and have increased to 7%, and we will continue to increase that. I'm hoping that we are able to increase that. Uh, Remfry and Sagar is also adept at handling all IP matters in Indian subcontinent through its network of reliable associates. So all of these countries that you're looking at is we have a close association over there, because sometimes a client sitting in US, Japan, they do not they do not know who are the firms in these countries, right? So they just route everything through us. Besides this, for the Indian companies, we go ahead and use our associates in the US, Japan, and Europe for filing the applications abroad. These are the practice areas. We are an IT boutique firm, so all of these areas of technology you already know. These are the various types of IP protection that you can do. All right, not defining what is intellectual property here. You already know it is creation of the mind. Uh, it is different from rights. Rights are exclusive legal rights that you get on the intellectual property. The idea is to provide a balance, between the interest of the innovator and the public, basically. So, like ma'am explained, you disclose your invention to the public, and you get the protection in return. The idea is also to foster an environment in which creativity and innovation can flourish. If you don't share, you cannot expect anyone else to share as well. And if no one else shared, you may not never know where technologically we have reached. So if you know where we have reached, probably you will start working beyond that point, right? So it is fostering the environment of creativity and innovation. These are the various types of IPR. Again, I'm not repeating for the sake of brevity. But yes, just quickly on the the term for protection. Patents 20 years, trademarks 10 years, renewal term 10 years, indefinite. Copyright 60 years from the date of publication or death of author. There are two different circumstances under which this applies. Design 10 plus 5 years, so 10 years with the renewal of 5 years extra, so 15 years. Trade secrets, again, indefinite in principle, unless the secret is leaked out. Geographical indication 10 years, renewal term 10 years, indefinite. Now, why do we need to protect intellectual property? I remember when I was young, people used to tell me that everyone should do law. And why? Because you get to know your rights. Otherwise, you're ignorant, you do not know your own rights. But what if these rights are profitable? They are also benefiting you. You know, intellectual property rights are those rights that benefit you. When you commercialize, monetize, there's value associated to it. That is, that is the actual benefit, apart from all the benefits that you get in terms of the high you get when you get those rights, right, at the beginning. But apart from this, statistically, all the studies that have been done worldwide, intellectual property has been found to be very strongly correlated with increased innovation, knowledge sharing and economic growth of the country. We talk about GDP, economic growth, the country's leading innovations. How does that happen? Somewhere it is correlated to what is happening at the ground level. How much research is happening, how much innovation is happening, and how much of that innovation is getting converted into intellectual property rights. So, whenever you think about inventing something or helping someone protect their invention, remember that you would be eventually contributing to the GDP of the country. So first of all, I would say it is an innovation driver, because inventors are driven primarily by the prospect of profiting from the ownership of rights. Then, in case of R&D industries, especially the healthcare industries, where a lot of research and development happens, there's a huge investment that goes into that research and development. How would they recover the the investments that needs to go into the next cycle of research and development? That happens through these assets, IP assets. It could be patents or any other IP asset, which, when monetized, gives back revenue, and that is reinvested to support further research and development. The new ideas, it gives you new ideas. Patents spark new ideas. In fact, Thomas Edison was very popularly known to visit patent office and read others' patent to get new ideas of his own. So it is not copying, it is getting inspired, right? Knowledge sharing and technology transfer. There was a study in 2008 by Esimoglu which showed that patents improve the allocation of resources by encouraging rapid experimentation and efficient transfer of knowledge between the firms. So, all of that at the technology transfer level, there's much more uh, things that get facilitated and happen at that level when you are innovating and protecting those innovations. It induces additional foreign direct investment as well. And many reports, many studies have been done, and it has been shown that it is directly correlated with the improved, increased FDI. So, study from Concordia University, and I've just mentioned one here in Montreal, found that in 1986, reforms strengthening the Taiwanese patent system stimulated additional inventive activities and induced foreign direct investment in Taiwan. And finally, patents guide competitors. Nobody want to guide competitors, but there is, there's a syllogism there. And, 2006 study by French economists found that 88% of the USCP and Japanese businesses rely upon the information disclosed in patents to keep up with the technology advances and direct their R&D efforts. Now, the example that I gave you, that unless you know what is happening, you won't be able to innovate further beyond that. This is how innovation happens. It is not just based on what you are doing, it is also based on what others are doing. So definitely there are a lot of opportunities when you protect your IP rights. It gives you a monopoly, an exclusive monopoly for a limited period of time over the new technology. It helps you to recapture investments, like I said, to reinvest it for further R&D. It increases the sales of the company and provides a competitive advantage to you in the market. It attracts investors. So again, it's just not the country, you come down, to the company, and the company growth also happens because of these IP assets. It increases the prospects and quality of merger, purchase, sale of the company. So it helps you, helps you to put you in a position to negotiate better, in the market. It is very well settled. More the IP assets, higher is the valuation, of your company. Not protecting in time can definitely put your innovation at risk, the brand at risk. So, there are several advantages of protecting it, but if you don't do it, you would not even realize what harm, can it cause to you. And sometimes, when you are working in an innovative field, you have to also take care of the fact that what are the patents that have already been granted. Suppose if you are inventing something and using a technology, you have to know whether it has already been patented by somebody else or not. Because if you still work on it, you will be causing infringement of the other's patent, and that will block your research activities. So you have to be mindful of that, and for that reason, many companies have these defensive and offensive patent strategies. Defensive would mean that they just file patent applications so that they don't infringe, and somebody else cannot file a suit for infringement against them, or cannot stop them from working on their stuff. And offensive is when they want to capture the market. Hundreds patent, thousand patents. Big multinational companies have big portfolios because they are blocking the space in the market. And I'll just give you this one example, and this is because so much have been said about me in relation to biotech. So I have this biotech example. What if the Cohen-Boyer patent, which was the first biotech patent, were never issued? So this will give you the whole journey of how the biotech industry that we see today, and which is about slightly over a decade old, if you see, developed over the years, and it is now, everything has shifted to biotech. Even the pharmaceutical has shifted to to the biotech industry. In 1973, for the first time in the history of biotech, a recombinant bacterial plasmid was constructed. Now, I'll not get into the technical details, but it was a landmark event because it gave birth to genetic engineering and recombinant DNA technology. What we talked about designer babies, you must have heard about designer babies. How do they make it? They get the genes, they put the genes and whatever trait you want, you select those genes, put it, and you get whatever result you want. So all of that is possible because of this genetic engineering and recombinant DNA technology, and that is still at advanced stage. A lot of which is an ethical issue, but there are a lot of other very advantageous applications to it in the agriculture industry, in the medicine industry, where we have been able to treat a lot of diseases because of these genetic engineering. Now, all of that started in 1974. There was nothing, there was no biotech industry at that point in time. Cohen and Boyer filed joint applications earning 3 patents in 1980, 84, and 88. And what was the outcome? A thriving biotech industry. It stimulated industry growth. Note this, patented rDNA licensed as platform technology through non-exclusive license for a moderate fee to 478 companies. Everybody in the field who ever was working in this area had to depend on this technology to take it further. So they were able to license this patent, and there was demand. 478 companies approached them for license. Revenue generation 241 million euro. Fortune helped funding R&D to foster further innovation. And of course, it promoted the R&D, innovation, and product development. Thousands of products were developed based on Cohen-Boyer patents, including drugs for heart diseases, anemia, diabetes, cancer. Now, definitely it gave them a competitive edge, but what is most important is just completely change the landscape of businesses, the industry, and the investors as well. It definitely promoted knowledge sharing because that is how innovation started happening in the field. Now, where do we stand, as India? And I would like to just give you a background. I will be doing a lot of talking right now because I want to share this information. we have just started, we have begun innovating. We are still a developing country. In 1995, there was a lot of pressure on us to become TRIPS compliant. Everybody knows about TRIPS, right? So it's an intellectual property related agreement. It has certain clauses that needs to be complied with, and whoever is a party has to sign that. But India in 1995, if you remember, there was no innovation. Our industry was still at a very nascent stage trying to grow. If at that point in time, if you would have signed that TRIPS agreement complying with all the clauses, it would have meant that foreigners, foreign companies would come in India, get the patent on all technology, and stifle the innovation in India. Indian industry would not have been able to grow the way it has been able to grow now. So, what the Indian government did, they said, okay, we will sign the TRIPS, but on one condition that we will not introduce product patents. Like we will not give patent to a certain set of technologies because that is very important for our Indian industry to grow. That helped the pharmaceutical industry because when product patents were not granted for 10 years, we took a window of 10 years, 1995 to 2005. So during this period, when the product patents were not granted, it allowed the Indian pharmaceutical industry to grow. To begin with, they started copying. We call it the generic industry. They started copying the drug. A drug that cost you say 5 lakh rupee per treatment, just costed about 1,000 rupee, when it was made in India. Do you think we could have afforded that 5 lakh treatment? Could that healthcare or medical facility would have been able to come to India if we would have allowed those foreign companies to get the patent on those products? No. So that is the journey we have covered. And the objective is to come at par with the rest of the world in innovation and protection of IP. If you can see here on the left side, we are already on the path. This is the Global Innovation Index. In 2019, we were at rank 52. This is from the 132 countries that are there. So 52 was a good rank, but consistently we have been climbing the ladder. In 2022, we were at rank 40, and we have maintained that rank in 2023. So India ranks 6th in the world right now for patent filings and 5th for trademark filing. That's huge. And if you look at the right side, here, these are patent filings by the Indian residents. If you would have compared it with the 2012 figure, it's 18,250 filings. And in 2021, there are 43,163. 137% increase in filings in the last 1 decade. And I also had this report, it will not open right now for some reason, but this is a trend that I'm showing you how innovation and IP protection is increasing. The filings are increasing from the Indian residents as well. And what is our objective? Where do we want to? Is it enough? What I showed you, is it enough for us? No. Look at this. China. This is 1.62 million patent applications they're filing annually. And where are we? 77,000. So China, followed by US, followed by Japan, followed by Korea, EP, and then India. So there's a long way to go, but let me tell you, right now, the entire focus of the government, the policy makers, is to touch that, to reach there. So there are a lot of reforms that are happening, not just at the operational level, but also at the policy level, which is encouraging innovation. And one of the examples is that now the government has given huge rebates to educational institutes for filing IP applications. Earlier, it was only individual or startups that used to get 80% rebate in filing of the application. Now, educational institutes have also been added to this group category, who can enjoy 80% rebate. And This has come only after realizing that rest of the countries, though, if China has these numbers, it is because of the amount of contribution that is being made by the educational institutes and the research institutes in patent filing. So there is a long way to go. Now, I'll give you an overview of the Indian legal system, and this is very common to all types of IP. You will be able to appreciate and connect with wherever you want to apply this. So we have Indian Patent Office. We call it Indian Patent Office, and in Hindi you call this Bodhik Sampada Bhavan. It says patent, but it takes care of the trademark. If you are dealing with trademark, you will call it trademark registry, copyright registry, or whatever. It has branches in Kolkata, Delhi, Mumbai, Chennai, where the patent applications and copyright applications are being filed. For trademark, you have another office, Ahmedabad, in addition to these four. So all of these offices, these are divided by way of jurisdiction. Suppose we are in Bangalore. If you want to file a patent application for an applicant residing in Bangalore, we would file it at the Chennai Patent Office. Likewise, somebody in Delhi would file at Delhi. Somebody in maybe Nagpur would file in Mumbai. So there is a territorial area that have been designated to each of the jurisdictions for filing of patent application and the processing. Then what happens if these applications get refused? They have to be appealed. There's a separate authority, appellate board. This appellate board, until April 2021, we had an intellectual property appellate board, which is a separate authority, but now it has been abolished. And what has happened after that? All the appeals, if your case gets refused, if your patent gets refused, if your trademark gets rejected, your appeal, which earlier used to lie at the Intellectual Property Appellate Board, would now lie at the High Court, because they have created a special intellectual property division. Now, these are the latest updates, which will just help you, stay informed as to what is happening in this area right now. And for all the judicial enforcement, when we say enforcement, what does it mean? We say filing, processing, grant, right? And what do you mean by enforcement? Anyone? What do you mean by enforcement of IP rights? Execution. Okay. So once you get the right, you have to exercise those rights, right? And when do you get this opportunity to exercise those rights? Is when somebody infringes. Somebody gets into your space, you push them back, right? So that is called enforcement. Now, for enforcement, all courts, you can file a suit for infringement in all the courts, starting from the district court. The court of first instance would be your district court here. Very quickly, because this has already been covered, this is a patent LPD, letters patent document that you get when a patent is granted. So, like we discussed, a patent is a contract. It is a contract between the inventor and the society. Inventor gives away all the information that he has and get a protection for a limited time. So in this case, this is also discussed, it is a negative right. You do not have the right over the patent, you have the right to prevent third parties from exercising that. Another very important thing that you should keep in mind is when it comes to Indian residents, there is a foreign filing rule that applies. So for any applicant, or any application that is in the name of an Indian resident, you have to either first file in India or obtain a foreign filing license and then file outside India. For example, you invent something and you want to file a patent application, and you are not interested in pursuing in India, you cannot just straight away go and file it in the US. You'll have to first obtain a foreign filing license from the Indian Patent Office. And what is the reason behind that? It is a scrutiny, it is a check, because the invention could be related to defense purposes. It could be related to, for example, you want to file a patent application, you invent something and you want to file it in the US. You have to first obtain a foreign filing license from the Indian Patent Office. And what is the reason behind that? It is a scrutiny, it is a check, because the invention could be related to defense purposes. or atomic energy. They want to review the invention and see whether it should be disclosed to any foreign country or not. Okay. So in case it is found to be relevant to defense purposes, a secrecy direction is issued and you won't be able to do that, do the filing outside India. But this is just the basic information that everyone should be aware of. When we talk about awareness of IP, this is one of the very, very critical information that you should be aware of. That either first file it in India or obtain the foreign filing license. This is the usual process to file an application and get the patent. So when you file an application, patent application, it could be either a provisional application or a complete specification. So this is all the information I'm just giving you. We will have the discussion, at the end of it. Provisional is when you have everything, still you do not have some things, right? So it is still the data is, yet to be collated, and the claims have to be drafted. Or maybe you're just unsure that maybe I can, come across something more in this. You file a provisional to secure the priority date. And then you get 12 months period to convert it into complete. You also have an option to directly file the complete application with all the information and the claims and everything. The application gets published in 18 months' time. You file the request for examination. Now, one thing that has to be remembered is that in practice, the applications are taken up for examination in the chronological order in which the request for examination is filed. So if you just file the application and you ask me, my application is not getting examined, why is it? Because first, you have not filed the request for examination. And second, even if you have filed the request for examination, you have to see when you have filed the request for examination, because it will be in that queue, of the request for examination in which the, in various applications, in the manner it has been filed. When this happens, you get the first examination report. Now, I was talking about reforms at the Indian Patent Office and generally the IP system in India. One of the reforms that has happened is that the rules have been amended to reduce the timelines. Earlier it was, when you used to get the office action, you had to file a response in 12 months' time. Now it has been reduced to 6 months' time. Hearings are appointed. Only 2 adjournments can be taken for 30 days each, again restricting the timeline. So I remember once I got an office action in my hand, and the patent term of 20 years had already expired. And it was hilarious because, even the patent office module did not detect that 20 term period had expired and issued the office action just to clear the backlog, So things like that used to happen. Things like getting an office action in 15th year when the applicant is just left with 5 years of the term period. Used to happen. It never made any sense to the rest of the world, and even to us. That has reduced considerably. The patent office, what should I call, the intellectual property office has worked very hard to clear off the backlog, and now we have reduced that timeline to almost less than 5 years. Like overall, from filing to grant, it is 5 to 6 years, and the effort is put in the direction of reducing it further to 3 to 4 years. So once you get the office action, you file the reply, and if there's still any outstanding objections, you get a hearing notice, and that's a final opportunity to present the arguments. And finally, if everything is found in order, the patent is granted. If not, it is refused, and then you have an option to appeal the refusal before the High Court, the Intellectual Property Division of the High Court. And when the patent is granted, you are under the obligation of paying the patent annuities, renewal fee. And there is a slight difference in the practice in other jurisdiction and India here. In other jurisdiction like US, you have to file the renewal fee right from year one. Whenever you file the patent application, you have to also start paying the renewal fee. But in India, it is payable only upon grant of the patent. and you pay the renewal fee for the, a consolidated fee for the rest of the years that have passed by. Patentability criteria, I'll just highlight one thing. We have already discussed it has to be novel, it has to be inventive, and it should be capable of industrial application. Just one thing that you have to remember is that an invention is specifically defined as a product or a process. It has to be either product or a process. It cannot be just use or a second medical use, or a new use. It cannot be that. All of these are the exclusions. When we talk about section 3B, where we say that non-ethical morality issues, I can share with you a lot of this objection comes against the stem cells. Stem cells which are used in therapeutics are considered as lacking against the public order and morality, because it can become anything. So all of those objections fall in. I'll not go through this again. So all of these exclusions. Again, you have a patentability exclusion under section 4, which for inventions that relate to atomic energy, and in case the invention relates to defense purposes. Now, this is one case study that I thought, and it was a very popular case study. Everybody wants to hear about this. So I thought it will, help you understand how innovation has been actually helping at the grassroots level. So this is a farmer. This was a farmer, Dharmveer Kamboj. He's no longer a farmer now. He's an inventor and an owner of a company. But Dharmveer Kamboj belonged to a poor farmer family in a rural India. He was a school dropout. He studied till 10th, worked as a rickshaw puller after that. He met with an accident, unfortunately. He was bedridden for months and faced severe hardship. In 2024, he got the opportunity to visit a farm, an aloe vera and amla farm, where he got an idea to start off a business of growing herbal and medicinal herbs. So the problem statement here was, when he came across this idea, the first problem that he faced was there was an exorbitant cost of existing machinery that was required to process these herbal plants. So as a direct solution to it, what he thought was he just built up one, machine to do this for the food processor. This is the kind of food processor that he built in the beginning. He borrowed money, struggled for 8 months in designing and building the machine, and was finally able to build the first prototype. And he took help of the local factory for fabricating and welding. Then somehow, because he was doing so much, he, sort of garnered and attracted a lot of attention from the nearby areas. And National Innovation Foundation scouted and helped commercialize this product. The global initiative of academic network assisted Kamboj in product design improvement, and he received marketing, business development, and IP protection support. This is the second version of his prototype, and this is the final. The right green one is the final product, and this is being sold at a whooping amount of $2,457, the large size, and the small one at 1,183. It has been exported to Kenya, and queries have come from Ethiopia. He's also got a patent on it. And look at him now. He's presenting his innovation to the president. And the below image is at the Geneva. He went there to present his case study at the WIPO office. So this is the impact of innovation and IP on society or the local community. You never know how it comes down to improving the lives of the people and indirectly impacting the overall socio-economic condition of the country. So all of these were the direct results from this. We already discussed about a trademark. Everybody knows what is a trademark very well. There are different type of, so many types of trademarks that you come across. Sometimes it is very confusing. Even we as attorneys sometimes, sort of scratch our heads as to, whenever there are overlaps. But a service mark, is one of those types where You are able to identify the mark and distinguish the source of a service. It is a brand identifier. For example, this McDonald and the Nikes just do it. Then there's a certification mark. What is the certification mark? It tells you about the quality of the product, right? Now everything is organic. Wherever you go, you are compelled to buy something organic which has the certification mark. It just represents the quality of the product. You are assured, it may or may not be, but you're assured that this is a good quality product. So that's a certification mark which promises you the quality. Trade dress. Now again, there's a feel good factor about certain brands. Everybody wants to wear brand and go for it. So how these goods are made or packaged adds value to it. And that is one reason why you go for it, not any other reason. So the examples are cherry red sole of Christian Louboutin and shoe and grills of the Rolls Royce car. You just identify, these, and maybe every brand of car would have that specific, style you would want and what you go for. Then there is also one type of trademark that has become very popular very recently, and that's the well-known trademarks. It was lesser known a few years back, but now almost everybody is talking about this. And most of the companies who have these brands are going for well-known trademark registration. And these are marks that have gained enough recognition in the market that if the moment you see this mark, this is the company, this is the quality of the product, this is what you can expect out of it. All of these on the Taco Bell, Mahindra, Tata, Bata, Bisleri, all of them are well-known trademarks. Even IBM is a well-known trademark. I know because we just did that a couple of months back for them. Trademark is not always a brand, but a brand is always a trademark. That is so true. These are some of the trademarks you can, think of. On the left side are your foreign companies, and on the right side you have the Indian companies. Yeah. Now, I didn't want to, there are already so many examples of trademark, there's no end to it. But this is a typical example that I included just to show you how disruptive branding happens, and what it takes to do it. ID Fresh, everyone knows. We are heavily dependent on ID Fresh. So, do you know the owner, the CEO of ID Fresh? Mustafa. Check him out on LinkedIn, connect with him. He posts really good stuff there. So he founded this company in 2006. He actually incubated. ID Fresh Foods had incubated in CFTRI, and I got to know when I went there for a lecture. But they started off from there. The problem statement was quality of dosa and idli mixes produced by the local vendors. Not every time you're happy. Sometimes it is not available, and a lot of things. So he started off with this, and just to supply fresh idli and dosa batter. I'm not going into history, but he started off with an investment of 25,000 rupee, and now he heads a 1,000 million company. The batter is freshly ground and packed every single day, completely free from preservatives, chemicals, and artificial flavors. In 2014, he did some packaging innovation and introduced a special type of packaging called the transformer pouch. Whatever it is. If you find a benefit in making it stand like this on the platform, then it's a great innovation, but all depends on how you perceive it. So then, of course, he scaled it up also and everything. And he did aggressive digital marketing to create awareness, build trust, and maintain relationship. That was branding. That was branding through a trademark that he had already secured, a patent that he had already got on ID Fresh. And what is the brand disruption? Because when other brands were focused on increasing shelf life by adding additives, ID did exactly the opposite. They supplied the batter which had limited shelf life with a tag that they are fresh, right? and 100% natural formula. And now I mean, it's been some time, but they came up with the vada batter nozzle also. The spout is patented. And now, I think recently, a couple of months back, they also came up with Spark Sip Tender Coconut. So again, all of these are innovations. They're constantly innovating with something or the other. Looking at the market. In fact, I remember there was one story, which he shared on the LinkedIn, that they thought that idli batter dosa are very very sought after in South, and what place could be better for it than Chennai? Bangalore, he already had a market, so he thought, we have 500 gram packet over here. Let's make 1 kg pack for Chennai, Chennai market, and he started making that. And there was no buyer in Chennai for those 1 kg packet. And he couldn't figure out, his calculation was perfect, this is the amount, this is the market, and this is my supply going to be, and it should get sold. Why is it not getting sold? And then when after doing a lot of market research, he realized that Chennai people, they're like South Indian, they want to have fresh batter. They won't keep the batter packet in the fridge. They are happy with 500 gram than keeping a 1 kg, buying a 1 kg pack and putting it in the fridge for the next day. They don't want to do that, so they don't buy that. He came back to 500 gram for Chennai market also, and got sold, and he has developed built a market there as well. So all this happening, the point here is that it is not just good enough to hold the IP, build the brand. You also should have the market knowledge and see how the market is reacting to your brand. Copyright, again, we have discussed the two scenarios that I was talking about in terms of the term of protection is, if it is an original literary, dramatic, musical and artistic work, it is 60 years from the year following the death of the author. And in case of cinematograph films, sound recording, photographs and so on, it is 60 years from the date of publication. Now we look at, Bollywood is one place where a lot of piracy happens and a lot of copyright infringement happens. The biggest challenge there is the ineffective enforcement. The environment that we have in terms of having enforcement of rights is not so great, and doesn't help. Even in terms of trademark counterfeits, when you go to the market, you see so many counterfeits, right? What are counterfeits? And probably sometimes you're just looking for one. But the problem is that there's so many of them that very big companies don't bother about them. Mid-sized companies sometimes do bother, and they take them to the court. But there's so much of cost involved in that at the end of it, when you develop a strategy, it may not be a very very profitable strategy to go with. So they're left. No enforcement. There's no exercising of enforcement of rights at that level. In case of copyrights, a very common question is, are remixes legal? Now these days we're just seeing, hearing so many remixes. All the good old melodies are being remixed. So are they protected under copyright? Can they be protected? Yes? No? The answer is there. Okay, yeah, it is definitely not the straightforward answer. Remix is a remix of the original version, and you cannot just do it simply by remixing it, right? You have to take permission. So you have to give prior notice of the intention, and you will, when you actually Google it or you will try to find out, you will see a lot of people arguing that remixes, when you put a lot of music and different beats, it is a new creation in itself, and it is distinct. But At the same time, when you look at the act, the legal provisions, it clearly says that if prior notice has to be given of the intention to make a remix. You make it, you do it, but prior intimation should be given to the owner. Royalties should be paid in advance. Negotiate, settle. If it is too different, let the owner decide that it is too different and settle for it. The owner has the right to inspect books of accounts, what is the kind of profit that you're going to earn through the remixes, and the remix will be launched after 2 years of making the original work. The very famous example is the Tama Tama song. And I just thought maybe, since this audience is the law students, you would be happy to hear some case laws also. Although I have actually not included many, but this one I couldn't stop myself because this is a very recent order that came out from the Delhi High Court. And this is RDB and Co. HUF versus HarperCollins. In this case, this actually involved legendary Indian filmmaker Satyajit Ray. He's a very famous filmmaker, and he's an author, composer, director, documentary filmmaker, and so forth, screenwriter as well. Now, in this case, the plaintiff, R.D. Bansal, actually asked Satyajit Ray to write the screenplay for and direct the Hindi film Nayak. So, R.D. Bansal asked Satyajit Ray to write the screenplay of this movie, which was released in 1966. In 2018, Bhaskar Chattopadhyay sought copyright permission from Satyajit Ray's son Sandeep Ray and novelized the film's screenplay. Now, what has happened here is Bhaskar Chattopadhyay in 2018 approached Sandeep Ray and he wanted to write a novel and he took the permission from the son of who wrote the screenplay. What they missed in between was that Satyajit Ray did not write on his own. He was asked to write by this. Yes. So, should there be a case of copyright infringement here or not? Yes. I'm very happy that you are so clear about it because it was long fought. And the issue before the court was this: who owns the copyright for film screenplay if the author was commissioned to write it by the film producer? Is it the producer of the film or the author of the screenplay? Producer. And the court, while arriving at the decision, the court actually put together all the facts of the case. That's the first thing you do. Whenever you present the case, you put together facts of the case and then start the analysis. The plaintiff produced the film Nayak. The plaintiff had contracted Satyajit Ray to write its screenplay. Satyajit Ray wrote the screenplay in its entirety because then there was no confusion of ownership with any other party. The defendant had not obtained a license from the plaintiff before turning the film into a novel. So the court came to the conclusion that Satyajit Ray was held to be the owner of the copyright. It was the first owner of the copyright, and the plaintiff's contention about owning the copyright in the screenplay was rejected. So this may, like in hindsight, it may look like as if it's very simple, but you have to also realize that there's so many overlaps, when we look at the enforcement of rights, IP rights. So when we look at the screenplay, it also comes under cinematography. When you look at the novel, it's writers. So you might just feel that, a person who is working on a screenplay would be covered under cinematography and this. So in this particular case, they have actually clarified that there's no connection. I mean, you cannot just assume that you would be covered. So that's the key takeaway from here. It establishes that the right to novelize the underlying work in a cinematography film is independent of the copyright held in the cinematographic film itself. And the right belongs to the author of the underlying work unless it is specifically assigned to the producer through an agreement. It is very, very important in IP to clarify or make it very clear who is the owner. Ownership of rights. It's the very first few steps that you should in due diligence determine who is the owner and whether there is any transfer of rights or not, which should be which should be legalized through a legal instrument like assignment. This is again designs. How much time do we have? 12. Okay. So again, not going into the detail. These are different types of bottles, design of bottles, which all can be protected under the design. One point that I want to make, and it is very confusing for many here, is what is the difference between patent and design? Suppose this is a bottle, and sometimes there are products that are being protected under Patents Act also for a patent, and you are also protecting it under the Designs Act for its design. But what the Design Act does not consider is the functionality. It is only the aesthetic appearance that matters. They will not look into how it functions. Sometimes they are medical devices and there's a technical effect, it's an improved one or something like that. They will not look at the improvement or how how the different features are configured there. They will not look at it. They will only see how beautiful it is looking. What is the color scheme? What is the pattern? All of that. That's it. Geographical indication, we have covered it. The advantage here is Darjeeling tea was the first one. The advantage here is it boosts the exports in the economy because we have suffered a lot as a country. If you look at how, even in terms of traditional knowledge that we have suffered because everyone has used our resources, our unique products without taking any permission. So this is, all of this is an endeavor to actually first identify. You have to identify this is ours, and then the others can use it for whatever it takes to use it. These are some of the GIs which are specific to Karnataka. You can take note of this. And finally, okay, let me just cover this quickly. We have been talking about trade secrets. Trade secrets is just the confidential information. Okay, so it is a confidential information. It is a secret, and it is only kept best till it does not leak out, right? Like ma'am also mentioned, there's no law that protects it. In India, there is no law. In India, there is no law under which trade secrets can be protected. But whenever there is some third-party involvement or misuse of trade secrets, the Indian courts have decided these cases based on equity and common law. Okay, so it is not that you may not get any justice also from the courts. You can get, provided you are able to prove that there has been a misuse and this was a trade secret. There are specific clauses for it, and this will be decided under the common law. So finally, I'm just summarizing quickly the challenges in IPR. We have discussed this thoroughly. That the first and the foremost challenge is the lack of awareness. Everybody should be aware of all the types of IPRs, not just to protect your rights if required, but at the same time protect the rights of the other, because you are students of law. Eventually you would go into these areas of law practice and enforcement. So this is very, very crucial. And when it comes to IPR, sometimes it is important to have knowledge of all the statutes because they are all interlinked at some level. So that is very important. When it comes to patents, it is definitely that you should have a science degree because that's the requirement in the statute, that in order to appear for the patent agent exam, you should have a science degree. But when the matters are fought in the court, then lawyers are the ones who are, like now the appeals are also going to the High Court. So they're the patent lawyers, they're the advocates, and it is not necessary that they are patent agents. Okay, so remember that whenever, and when it comes to court, fighting cases in court, IPC, all the other statute are all interlinked. Evidence Act, everything is, applicable everywhere. So just don't, just don't stop thinking about patents if you don't have a science degree. It is always possible for you to practice this profession. And of course, trademarks, copyrights, and other forms of IP are always open. The backlog issues and all are another challenge area that has been addressed. Inadequate protection of IP rights. Like I said, there are a lot of patent exclusion clauses, but the idea behind putting them is to protect our Indian market, not give patents to those inventions which will block any sort of or it'll come in the way of protecting the interest of the public at large. So that is the idea. Cost of protection and enforcement and litigation is very high, so it's not something that everybody wants to go ahead with. So that is another challenge that comes in the way of IPR enforcement. IP protection in digital age is another challenge that we are facing now, because you have software, you have open source code, you can easily access, modify, nobody to catch you. So this is another area. Counterfeit and piracy and outdated IP laws. We really need to, the pace at which technology is advancing, we need to update our IP laws. And finally, IP documentation, ownership assignment, and confidentiality agreement. All of these are very, very important part of due diligence that, if not addressed, can create serious issues. I'll not go through this in detail, but I'll give you a crux of this. It is just an extension of challenges that I was talking about. This is a case study where a company was doing very well and it had a lot of patents in its name, a big patent portfolio, a huge investment. Like a lot of big companies had invested in this company and they were getting a lot of rewards and everything. And suddenly, one fine day, it got bankrupted. And there was another company who saw this company. That company was iDirect. The iDirect approached to buy this company just because of its patent portfolio. But when they did the auditing, they realized that even though they had such a huge patent portfolio, they never realized the importance of it. They never monetized it or did not realize the value of it, which could have saved the company not just from being sold, but at the same time it would have added to the growth of the company if it would have been properly understood, if the patent portfolio value was properly understood. So all of these are details. I'll leave the presentation here. You can just go through this case. It is a very interesting case. So again, the takeaway here is that it is not just important to get IP. First of all, you should have the awareness of getting an IP, get the IP, but it is still not enough to just get the IP. You should know the value of your IP. You should be able to monetize and gain benefit out of it. So that's it from me. Takeaway is innovation and IP has a direct impact on the market. The why is this, that please contribute to the growth of the country. And that is how, we would be able to achieve that number. And yes. And of course, IP definitely improves the overall brand. It enables you to license and everything. All of that we have discussed. The last point is there. I've kept it. It offers promising career opportunities. Okay. So not that I'm promising any job, but the point is, see. And very good. We have 5 minutes. So when I was doing this research at Terry, and I was asked to write the objectives for my PhD I was about to enroll for a PhD. For every sciencey discipline, that's the next step. You want to do PhD. Day and night you're dreaming about that, right? So I was just at that stage, and I had a couple of friends who were into this line of IP, and it was 2005, 2005. So not everyone knew about IP. So few people knew about it, and there was a patent agent exam coming up. I found it so interesting that I thought I'll give it a shot. I gave it a shot, and then there were two options: whether to go for PhD or switch the line to IP. And I just opted for latter. And since then, there's been no looking back. It's been 17 years now, and every day is more interesting than yesterday. So every day challenges you in some or the other way, because you are reading inventions, handling matters, dealing with companies, Fortune 500 companies, and you are connected with what is happening right now at the global level. So I think, and then at the same time, not losing on applying your knowledge. Every day you just keep on adding, to what you already have, and not replace it. So patent, trademark, copyright, any form of IP you may take, it is a very, very good, career opportunity that you can explore at this point in time. That's it. Thank you. I'm also open to questions. You can ask general questions also.
Coca-Cola and other things, there's a trade secret.
Hmm.
Now using it, they make mocktail.
Mocktail.
Yeah.
Yeah.
Then is it misuse or is it manual?
You know the trade secret.
Yeah.
Like using the Coca-Cola content to make a flow, not to make something else.
That is your trade secret then. You can make a mocktail out of the Coca-Cola.
Yeah.
See, you would not be able to make Coca-Cola.
Okay.
You would be using Coca-Cola to make a mocktail. And if you want to keep it a secret, you can keep it as your trade secret.
It is not the wiring.
No, not at all. You would not know. See, Coca-Cola we anyways use. We have been putting ice creams in Coca-Cola and having it. I don't know how many of you have had that, but yes, we have been doing that. It's not a violation of trade secret. Trade secret violation happens in a very particular scenarios, and I can tell you when. Uh, a lot of information lies with the employees of the company, who are working. And these days we see a lot of attrition rate, employees change companies, and with them the trade secret also goes. And these ways you would never know where my trade secret is used if it is leaked out, if there is no connection, right? Most of the time, in case of misuse, there is a connection. Either it could be, ex-employee who has done that, or an ex-partner in the company.
One of my company happened.
Hmm.
The marketing person has taken away all
Yes,
my.
that's a very typical scenario. That's a very typical scenario. That is what, and in those cases, you rely on your CDAs or the employment agreement or the partnership contracts that you have signed. So it is very important, as law students, all of you, due diligence is your first tool. When you have these issues that come up later on, the first thing the court asks is, where is the evidence? Give me the evidence. And that evidence is your legal instrument. Either it could be a contract, an agreement, and just don't use. We have sample templates for everything. but don't just blindly, use those templates. Read each and every clause, see the applicability of the clause in the current scenario, the situation, and then finalize that agreement, because the clauses can change from situation to situation, people to people, company to company, depending upon what is the interest. Like in this particular case, if there has to be a clause regarding a trade secret or confidential information, in the agreement. If that is not there, then you cannot enforce it. Even under common law, you cannot enforce it in the court of law. So that is something that you have to take care of.
One more thing, usually on these, the retail shop channel, they purchase already some jaggery or some floor, which already one value addition is already there. And they purchase it under one brand name. But later when they purchase, get it in terms of printer, they repackage for the half kg and they put their own brand.
Yeah, so these are all workshop improvements or workshop modification that we do. We see a lot of that in the market. The only thing is that, again, these things fall to an extent, it would either fall in infringement or counterfeit, but not trade secret. Mhm. Trade secret is something, and if at all it does, if you see that there is something that they're using which was a part of the trade secret, companies have a very well defined trade secret. If you're just thinking that it's a secret and you know it and nobody else know, it's not like that. It's a well documented trade secret. It's a company's asset. And I'll give you an example in practical scenarios how it happens. It's a big chemical company and they are making something. This is a product which they have got patented, and there's a process of patenting, making that product that they have got patented. Okay, there's a slight change in the one of the reactants, one of the items that they are using in that process. Now, for getting a patent, what do you want? You have to have an invention, a process, or a product which is novel and inventive. But in light of that patent, for which you already have on the process, that process is already known. You're only changing one reactant. It will not be considered as inventive. It will be considered as obvious modification of the process. You will never get a patent on it. Hmm? So and it is very crucial to their business. So what do? They protect it as trade secret, so that they keep it secret, they keep using it, they don't disclose it to the outside world also. Uh, and there is no other way also, because you cannot patent it. Right? So these are very real examples of how trade secrets exists in this world. Thank you.